Good morning, everybody. We'll just wait a few seconds for people to come in and join the webinar this morning. So I think we can make a start. As I said, welcome everybody to this 3-hour employment law update session. I'm so pleased to have been asked back again, and I've got some great updates for you. For those of you that may not have met me before, I'm Toni Trevett. I work for a small consultancy called Complete HR Limited. We work for lots of organisations supporting their people management and development. We work for HR teams as well, do lots of training, investigations, dealing with mediation and difficult issues as well. And I sit and hear cases for the South London Employment Tribunal too, and that's the part of our judiciary that deals with unfair dismissal and breach of contract and discrimination cases. And I always look out for interesting cases, ones that catch my eye. So I thought before we get started, I'll just tell you about a couple of those. I think there's a few that have been interesting, maybe for the wrong reasons to me, because they've been slightly either funny or slightly out of the ordinary. So this is the first one, Mr. Gaines and Third Space Holdings Limited. And although most employment tribunals are serious matters and involve, serious issues, some, as I said, grab your attention for maybe different reasons. And I was a little bit surprised with this case. It's about a 64-year-old personal trainer from Berkshire who sued the luxury health club where he worked for age discrimination because the music they played he felt was too modern and offended his ears. He complained that the gym's insistence that the studio where he conducted fitness workouts play tunes that are no older than 18 months put him at a disadvantage and caused him a detriment by reason of his age. His employers, of course, defended this and didn't agree with him. They described themselves as a cutting-edge modern organisation, and image and presentation was a priority for them. And they said at the hearing that they actually had a music policy, and that stipulated that any music played in the club must be produced and released in the last 18 months. The cynic in me thinks maybe they created that policy for that hearing, but I'm sure that's not the case. Anyway, they said there was no bar on playing old music as long as it was a recent recording or a remix. Mr. Gaines, however, said that as he doesn't listen to Radio 1 or go clubbing anymore, he was discriminated against by unfamiliar music. Anyway, to cut a long story short, he didn't win his case, and the judge found that the music policy was a proportionate means of achieving a legitimate aim in order to have the club play the latest and best music production. And the judge added at the end that he was sad that at this stage of Mr. Gaines' illustrious career, he should find himself expanding great emotional energy on recriminations and bitterness. So there you go, that told Mr. Gaines. The next one that caught my eye, and I'm sorry for any of you that don't like spiders for the photo, is Mr. Richardson and West Midlands Trains Limited. And I'm sure you're already thinking, what would a tarantula have to do with an employment tribunal case? Well, this might be one of the most bizarre ones I've read about in the last 12 months. It's a case where a train driver, this Mr. Richardson, was sacked for gross misconduct for workplace pranks that involved leaving the shed skins of harder to say than I thought, tarantula and a snake, where a fellow employee would find them. So he was dismissed, and he brought a claim of unfair dismissal and wrongful dismissal, and he won. You can't make this stuff up. He'd been working for West Midland Trains for a long time, and because his colleague, they called her Driver A, had said how squeamish she was to insects and spiders and snakes, he decided to play a prank on her and actually left this skin in her pigeonhole for her to put her hand in and find. Well, as a result, she, I've got to say it, jumped out of her skin. And she called him a whole range of very rude names. And because it went so well in his view, he decided to do it again sometime later, this time with a snake skin in her pigeonhole. So to fast forward, she raises complaints and grievances and writes to her manager and deals with this formally. And as I said, he goes through a disciplinary process. The allegation is bullying and harassment, and he was summarily dismissed, which means dismissed without notice. However, the tribunal found in his favour and said he had been unfairly dismissed. And the judge in this case said that this was a prank, no matter how poorly judged. And it wasn't something that was going to give considerable shock, cause someone ill health, or lead to a catastrophic accident or business interruption. And in fact, the judge said, had this have been left somewhere in her train cabin where she worked, then of course that would have had far more serious consequences. But that didn't happen, and it was just a prank, and he should not have been dismissed for it. So there you go. I'm not sure it sends all the right messages, but perhaps a final written warning would have been a better result in that case. And the last one that I picked out for you is a banter case. And to be quite honest, I could do 3 hours on banter gone wrong cases. And this is a nickname case, and it kind of reminds us to be really careful with these things. In this case, Mr. Robson was made redundant from his job. He worked for this company on the Isle of Wight, and he was 69 at the time he was made redundant, and the oldest worker in their business. And there had been a downturn. There was the loss of a major contract, but he was the only one selected from this group to be made redundant with no formal process, no scoring, no proper consultation. All the things that are essential for fair redundancy just didn't happen. So he brought his claim for age-related discrimination for being dismissed by reason of his age. Now, I'm sure you're wondering, where does the nickname point come in? Well, the reason that this is also a nickname case is because he claimed harassment as well. And that's because the colleagues gave him the nickname of Half-Dead Dave. So that was what he was referred to at work. Or if they wanted to shorten that, they just called him Half Dead. And he said he had never complained about it because it was easier just to put up with it. He didn't want to make things worse by having a difficult relationship with his colleagues. His supervisor and manager referred to him as Half Dead or Half Dead Dave, although his manager did try to argue that he didn't. He only called him Disco Dave, which was denied. And to cut a long story short, the tribunal also found that that kind of a nickname was age-related harassment. So unfair dismissal by reason of age and age-related harassment for the nickname Half-Dead Dave. And in fact, he was awarded about £25,000 for that case. So but for treating someone reasonably and following a proper process, that became quite an expensive mistake for that organisation. So let's go on with what we're going to cover today. So we'll look at what's recently new. So we'll just do a recap of the very last point from the last webinar that we did. What's already arrived or on its way in 2024. We'll touch on the changes in statutory calculations, excuse me, although we haven't had them all yet. A couple more bits of interesting case law, and then we'll round off with what else is to come. We'll try and have a break on the hour, so we'll have 2 breaks. Please, if you've got any questions, put them into the Q&A, and I'll try and cover them off when we come back after each break. So that's a good way to deal with any questions that you might have. So let's start with 2023, and I'm not going to go over everything we covered last time. But I will mention what the last change was, and it was to do with strikes. And of course, that's very newsworthy throughout last year. On the 10th of August last year, it became unlawful again, because it used to be unlawful, then it became lawful, then it became unlawful, all in the same year. It became unlawful again to use agency workers to cover people that were out on strike. So at the start of the year, we had new legislation to say that we were able to use agency workers to cover employees on strike, which had not been allowed before. But that was overturned relatively quickly by a claim to the government that it wasn't lawful. And we're back to it not being possible to use agency workers. Of course, employers can cover striking staff by engaging temporary staff directly. It's just the use of agency that's outlawed. So they can have temps that they directly employ. And they can move employees around, ask managers internally to cover positions where people are on strike, use volunteers, use bank staff. There's lots of other options. They just can't use agency staff. I don't know if any of you remember the Quorn factory strike last year. It lasted for 11 or more weeks in the end. And Quorn deployed all their managers to keep production going. Excuse me. It sticks in my mind because the placards that they were waving around on the picket line said, "Hey, Quorn, you need to beef up your pay offer." Nothing like some humour to go alongside a full-blown strike. But there you go. The new legislation, in addition, also brought about some significant increases to the maximum damages that could be awarded against a tribunal who took part in unlawful industrial action. And industrial action becomes unlawful where there hasn't been a proper ballot process or where the trade union has disowned the strike. And for unions with 100,000 or more members, the cap on damages went from 250,000 to 1 million. So a big increase to what it could cost if a union doesn't get every part of that process right. And then the very last change we had in 2023 was the minimum service levels in strikes legislation. And this was something the government published that set out that organisations would have to put in minimum service levels for things like rail and ambulances and border security staff and so on. And that came into force at the end of December 2023. Of course, if the Labour Party get in and we could have a general election this year, they have already said that they'll repeal this legislation. So we may not have it for long, but let's wait and see. So here's the first question for you. And this actually was a question that got submitted a couple of weeks ago. So how long do you have to be continuously employed to benefit from unfair dismissal rights? And I've given you 5 options. So please pick away as to which one you think. Do you have to be employed for a day? So do we pick up our unfair dismissal protection rights straight away? Do you have to be employed for a month? Is it at the end of a probationary period? So once you're successfully through that, is it you need a year's service? Is it you need 2 years service? So hopefully you can make your selection. You'll have to help me with how I see the results, or are they coming up? Here we go. Thank you. So we've got 19% say you have to have a day, so it's a day one right. Nobody thinks a month. Oh, a lot. 32% think it comes in at the end of a probationary period, 2% 1 year, and most 47%, nearly half of you, think it's 2 years. Excuse me. And the majority have it. The 47% are right. You do need 2 years continuous employment to pick up your unfair dismissal rights. Now, those 19% of you that picked day one, that is true when it comes to automatically unfair dismissals and discrimination at work. But for standard unfair dismissal claims, you have to have 2 years service. somebody asked me recently, what's the difference between a dismissal and an automatically unfair dismissal? Well, there are about 60 different reasons that fall within the concept of automatic unfair dismissal, and they're nearly always related to statutory rights. So if you dismissed someone because they had applied to take paternity leave, that would be automatically unfair. If you dismiss someone because they made a protected disclosure, they had a whistleblowing issue, that would be automatically unfair. You don't need the 2 years. If you dismiss someone because they raised a health and safety concern at work, that would be automatic. So there's about 60 of them. And then alongside that, any dismissal that's related to any of the protected characteristics is also going to be automatically unfair, and you don't need the 2 years service. So if you dismiss someone on the grounds of their age or race or sex or so on. Okay, so that's answered the question that came in a few days ago or a week or so ago. So we're going to move on to this year now. And there was, if you remember, and you were here on the last webinar, there was an unprecedented number of bills and private members' bills that were being adopted by the government to introduce lots of new rights for people, many around the work-life balance and initiatives like that. So I'm going to run through what's now law for you and what's about to become legislation in 2024. So let's start with something related to equality and diversity. This is 1st of January this year, so I'm going to go in date order. So we said goodbye on the 1st of January to the need to share a protected characteristic when somebody brings a claim of indirect discrimination. Now, there's lots of different types of discrimination in the Equality Act of 2010, and one of them is called indirect discrimination. And this is where an organisation has working practices, policies, or rules that seemingly are the same because they apply to a large group of people or even to everyone. But in reality, some people are adversely affected or worse off or unable to comply because of a protected characteristic. And an employer is able to objectively justify whatever this rule or policy is if they've got good business reason and they can't deal with it in any other way. So I'll give you an example of what is indirect discrimination. A manufacturer needs to make some redundancies, and they do a lot of business. In fact, most of their business is with certain suppliers in India. So the employer decides that when they're considering who to make redundant, they are not going to include the person that speaks Hindi, for example. And now this, of course, might discriminate against people who are not of Indian heritage. However, the employer may be able to justify the indirect discriminatory impact of that rule, that decision, if there is a genuine business need that cannot be resolved in a less discriminatory way. So in this case, if they only had one person and they could show the essential business need to retain that skill, then they would probably be able to justify the indirect discriminatory impact. So what's changing then or what changed on the 1st of January? Well, when you claimed indirect discrimination pre-January the 1st, you had to have the same protected characteristic as the disadvantaged group. So in my example, you would have to have that characteristic in order to make use of that indirect discrimination claim. But what's changing is that you will no longer have to share the characteristic of that disadvantaged group and in order to make a complaint. So let me give you an example of how that might work in practice. Currently, only women with childcare responsibilities who are not permitted to work part-time could bring and succeed in an indirect sex discrimination claim. A man could not bring that claim. Whereas now, this change has happened. A man who is also refused part-time work in relation to childcare activities, for example, could now make a claim of indirect sex discrimination. So it's a really important change, and one that could make a difference to a lot of people. So the change is you don't have to share the characteristic of the group that is indirectly discriminated against by whatever the rule, policy, provision or criterion is. Okay, so a technical change, but quite an important one. And I thought I'd give you a quick reminder of what those 9 protected characteristics in the Equality Act of 2010 are. So I put them up on the screen there. These haven't been added to, these are the same that they have been throughout, but just by way of a reminder for you. Okay, the next change in legislation I want to talk to you about is connected to working time regulations. So again, from the 1st of January 2024, the requirement for an employer to keep separate records of the daily working hours of its workers and employees goes, provided that they're able to demonstrate compliance without doing so. So this is a change from being obliged to being able to demonstrate compliance. So as long as an employer can show, and it might be in other ways, that people aren't exceeding the maximum working hours or exceeding or not having the right rest periods and so on, there's no longer a requirement to keep a separate record of daily working hours. Now, I work with lots of different clients, and I can think of quite a few of them that didn't keep a daily working record in any event, but there you go. So it'll be interesting what the reality of this change might be. It was brought around because the government considered it was too time consuming. But as I said, I've found lots of organisations that weren't doing it anyway. But there you go. So that's the change to working time regulations. Then we've got some changes to how much we will be fined for employing an illegal worker. So currently the civil penalty for employing an illegal worker is a maximum of £15,000 per illegal worker. And that's when it's an employer's first offence. If an employer is a repeat offender, then the maximum fine increases to £20,000 per illegal worker. And it's been around 10 years since we had an increase in these fines. So I think it was 2014, in fact, when they were set at this level. And now from an announcement last August, these fines have been tripled. So the civil penalty regime has really increased. So instead of it being 15,000 per illegal worker, goes up to 45,000. And instead of 20 for a repeat offender, it goes up to 60,000. And this came into effect on the 13th of February this year. There's a new code of practice that's been released to ensure we prevent illegal working. And you may well be familiar with this already, but all UK employers must conduct right-to-work checks on every individual that they intend to hire in order to have a defence against allegations of illegal working. And those checks have got to be carried out before the individual starts work. It could be on the morning, but they can't start work until the checks have been done. They have to be done in a certain way. So if you're at all unsure, go and have a look at .gov.uk for the steps that you must take to carry out those right to work checks. Very expensive to get that wrong. Excuse me. Now I want to talk to you a bit about changes to come in April. There's quite a few that are coming in on the 1st of April. So we've got new rules on how to calculate holiday entitlement and pay for irregular hours or part-year workers whose annual leave year commences from the 1st of April onwards. So if you're already into your annual leave year, this won't apply until next year. But if your annual leave year starts on the 1st of April, it will apply this year. And this is the classification of these types of workers. So the new regulations give a definition for irregular hour and part-year workers that these reforms apply to. So irregular hour workers are people that work wholly or mostly in a variable pattern. So their paid hours under the terms of their contract in each pay period will vary. And these could be casual, 0 hours, or any of those kind of irregular contracts. You wouldn't qualify for an irregular hours worker if hours are fixed. Instead, they're going to be different each week. A part-year worker is really, as it says on the tin, to be honest, it's someone who's required to work only part of the year, and there are periods in the year of at least a week during which they're not required to work. Think teachers, for example. And the guidance also states that part-year workers may have fixed hours. So this can include term time workers. So those are the definitions. Now let me tell you about the changes. So there was a case called Harper Trust and Brazel, and this meant that employers had to change the way they were calculating the holiday entitlement for those irregular hours, term time workers, 0 hours contracts, and so on. And what the court held in this case was that the 5.6 week statutory holiday entitlement, that's the minimum in the UK, could not be prorated for part-year workers, which was a bit mad as a decision. So the government's decided to legislate in response to that case and introduce this new holiday entitlement for these category of people. So, as I said, it's for holiday years beginning on or after the 1st of April, and it's an accrual method throughout the holiday year. So someone's entitlement accrues at 12.07% of their hours worked in the pay period, rounded to the nearest hour. So it's always easier with an example. If you had a monthly paid person who worked 100 hours in their last month, they will have accrued 12 hours of annual leave. So you accrue as you go at the rate of 12.07%. Workers can't accrue more than 28 days because that's the statutory amount. And the draft regulations also set out an accrual method for family-related leave or sick leave for those categories of staff as well. And this is all based on average hours over a 52-week period. So if you have people in those categories, look out for this change on the 1st of April. It will alter people's annual leave entitlements. Secondly, as part of these changes, the concept of rolled up holiday pay comes onto our legislation book. And this will allow, again, our irregular hours workers and part-year workers to receive rolled up holiday pay each month instead of being paid when they have annual leave. So it was always unlawful under EU legislation to do this, to make rolled up holiday payments to people as they go through their employment. However, this amendment will change that. And using the same percentage, it says an employer can choose to either roll up holiday pay and pay as you go, or to give people paid holiday when they take holiday. You're not going to do both. And if you decide to roll up and accrue and pay holiday pay, it's again paid at 12.07% of the worker's earnings in each pay period. So there is a choice. You either roll it up and pay as you go, or you calculate how much leave is due, and then you pay it when someone takes the actual leave. Excuse me. Right, here's our next question. So can you carry over untaken holiday from one year to the next? And I've got 4 options for you there. No, you can't. So it's use it or lose it. And yes, you can if you've been on long-term sick leave. Yes, you can if you've been on long-term sick leave or family-related leave. Yes, you can if you've been on long-term sick leave, family-related leave, or you've not been allowed to take it. So choice of 4 this time. Let you have a minute to decide. Okay, here we go. So the no's are 16% of you. Yes to long-term sick, 2%. Yes to sick and family-related leave, 8%. And by far the majority, 73% of you have gone with yes to all three options. So if on long-term sick, family-related leave, or you've not been permitted to take the time off. So very good. You're definitely on top of this change. So these are the rest of the changes that are coming in on the 1st of April. So the first one of those three, workers on family-related leave must be allowed to carry over their holiday. So think maternity, shared parental leave, and so on. The regulations specify that if you've had time off for those reasons, then I think a lot of employers do this anyway, but case law has established that the carryover is required. But these amendments to the working time regulations will catch up the legislation with the case law. And this requirement applies to the whole of the 5.6 weeks annual leave. So it could include bank holidays as well. Read your contracts or relevant policies to see if that would expand to contractual holiday too, because some people might give, 25 days plus bank holidays or 30 days plus bank holidays. So it's really important. I was doing this with someone recently. When someone's about to go on maternity leave and you're thinking about when they want to start, when they want to come back, how much holiday they've got, how much they can carry forward. Don't forget the bank holidays are part of, for some organisations, the 5.6 weeks. So you have to factor in bank holidays not yet taken to be rolled over as well. Oh. Okay, so that's the family-friendly part. Then we've got the long-term sick part. Again, the regulations also now will specify that annual leave should be carried over where a worker has been unable to take it due to long-term sickness. So if somebody is off sick for, 6 months, they are able and hadn't taken any annual leave. When they come back, they will have the full year's worth of annual leave to take. So to avoid workers accruing large amounts of holiday if they're off for a long time, the regulations state that carried forward holiday has to be taken within 18 months of the end of the holiday year in which it accrued. So if my holiday year is January to December, I've been off sick for the whole year. If I come back to work on the 1st of January 2025, I will have, for example, 25 days holiday to carry forward to 2025 and take within a further 18 months. So I know that some people think if you're off on long-term sick, why would you need to accrue holiday? But the legislation is really clear on this now, and the case law has been saying this for some time. So it's a right that definitely transfers into future holiday years. Okay, and then the last one of those three was where workers have not had a reasonable opportunity to take holiday, and they are able to carry over their holiday too. Now, this is a really interesting one because I'm not sure that many employers are aware of this. So this will be an obligation on employers to encourage workers and employees to take their full holiday entitlement. Otherwise, there may be claims that they should be able to carry them forward. So workers will be entitled to carry over untaken annual leave if the employer has not either recognised that they've got the right to annual leave. So where an employer has got the status wrong of someone, i.e. they think they're self-employed, but in reality, they're an employee. So because they thought or treated them as self-employed, they didn't give them any paid holiday. Then, of course, if that's challenged and successful, that will generate annual leave that needs to be taken or carried over. If the employer has not given them a reasonable opportunity to take the leave, so where there's been excessive amounts of work or even holidays have been cancelled by the employer, then that obligation will exist. So it will definitely be where people haven't been given, and the term is reasonable opportunity to take their leave, course, the word reasonable features all through our employment legislation and cases, and it's reasonable to a court's mind, to an employment tribunal's mind, rather than reasonable to what you might think. And then lastly, they will be able to carry it over if they have not been informed that untaken leave will not be carried forward and will be lost. So I think it's really important for employers to think about this. The whole concept is that people should have the time off in any event. And I think now a sensible employer will have processes in place to monitor how much annual leave people have outstanding and to encourage people to take it. And I've certainly advised a client just in the last week or so to have a steady, twice a year or 3 times a year standard letter that goes out to everyone, standard email, that says, please ensure you book and take your annual leave. It will be lost if you don't, by the 31st of December or whatever. So it's probably good practice to do that and just keep on top of it. Good. So those are our 3 changes that related to that poll question. And then finally, the 6th alteration in this legislation is about normal pay for the purposes of calculating holiday pay. So the new regulations will set out the elements of pay that must be included when establishing what a worker's normal rate of pay should be for calculating holiday pay. So for those of you that get a basic amount of pay and nothing else, it's really straightforward how much you should be paid when you're on holiday. For others that maybe receive commission payments or incentive, productivity or performance payments or bonuses, or professional status or length of service payments, overtime pay, shift allowances, shift premiums, standby payments, emergency call-out payments. There are lots of extras that some people get as part of their remuneration. And what the new legislation says is that people should be paid normal rates of pay when they're on holiday, and it should include those various things. And now this part of the provision only applies to 4 weeks of someone's annual leave. So it's specific to what was the original EU paid annual leave right. Of course, the contract might say something different. You might need to check, or an employer can choose to apply this to every part of someone's annual leave. But there you go. It's putting again the case law that we've had into our legislation. What is difficult to see is how a genuinely discretionary annual bonus might be said to fall within the scope of normal remuneration if that bonus is dependent solely on company performance with no personal performance component. And I think if it's a company bonus, annual, non-discretionary, based on the company's performance, that's probably not going to be included. Okay, so those are the changes that we're going to see that relate to holiday and working time regulations. Also on the 6th of April, we're going to see a number of other changes, and there are 4 principal ones. First of all, flexible working requests. So we've got revised provisions relating to flexible working, together with when you can make that request and how often you can make it. So I'll explain that one to you. We've also got redundancy protection being expanded for people that are pregnant, returning from maternity leave or adoption or shared parental leave, and so on. So this expands that protection from redundancy. We've got some changes to paternity leave. And finally, we've got a new right coming in called carers leave. And that's a new entitlement to a week of unpaid carers leave per year. So let's have a look at these in a little bit more detail for you. Obviously, flexible working is a really common right that people make use of at work. So I think pretty much every employer will need to be aware of this and amend their policies accordingly. Excuse me. So the right to request flexible working is supported by an ACAS code of practice, and that's been revised as well. acas.gov.uk is a really, acas.org.uk is a really helpful, useful website to keep up to date with legislation. So what will happen with our flexible working is that there'll be a number of changes to the existing right to request. And remember, it is a right to request. It's not a right to have. But I think it's a right to request with teeth, because there are only a limited number of reasons that an employer can ever turn somebody down. But I've summarised on the next slide just what is changing. So employees will have a day one right to request flexible working in this new legislation. Currently, employees must have 26 weeks. So that's a big change. Employees will be able to make 2 flexible working requests in any 12-month period, rather than the current limit, which is 1. Excuse me. Employers will be required to respond to flexible working requests within 2 months, which is shorter than the current period, which is 3 months. And that has to include any appeals and trial periods as well. Employees will no longer be required to set out how the effects of their flexible working requests might be dealt with by their employer. So if you have standard forms that include that question, that will have to change. And lastly, employers will be required to consult with employees before they refuse a request. But there's no clear clarification on what constitutes sufficient consultation. But safe to say, the more thorough you are, the less risk there is. And these are the reasons that we can reject a flexible working request. I won't read them to you because hopefully you can see them up there, but they're pretty broad. There's lots of reasons that somebody might be turned down, but getting it wrong can be really expensive. You know, for example, if you said, well, given the change you make, we won't be able to recruit someone else to do the work that you won't be doing, but you haven't actually put out an advertisement and tried, then it's going to be very difficult to use that as a defence. It's not a defence to say, I think this might be the difficulty. You would have to do more to demonstrate what the difficulty would be. There was a case just not that long ago, a year or 2 ago, called Thompson versus Scan Crown Limited, trading as Manners, which I think was a very clear warning to employers in terms of demonstrating how important it is for organisations to consider flexible working requests really carefully. And this decision had a lot of media attention because the Employment Tribunal found that when this employer refused Alice Thompson's request to reduce her working hours after her maternity leave, that was found to have been unlawful discrimination, and she was awarded £185,000, which is quite a lot of money. So she worked as for this estate agency, and including her commission was earning about £120,000 a year. So she was a very successful employee, and her contractual hours were Monday to Friday, 9 till 6. Now, she requested when she returned from her maternity leave, to have flexible working that reduced her working days to 4 a week, so from 5 down to 4, and reduced her working hours so she finished at 5 instead of at 6, so she could pick her daughter up from nursery. So those were the 2 changes she wanted, and she was turned down. She appealed, and she was turned down on appeal. So off she went to the Employment Tribunal. She resigned, and she brought claims for pregnancy and maternity discrimination, for sex discrimination, harassment related to sex, indirect sex discrimination, unfair dismissal, unlawful deduction from wages. I mean, she threw the book at this employer, and she won her indirect sex discrimination in relation to flexible working. And the Employment Tribunal essentially found that her employer could have accommodated this change. So I think it's so important to consult, to discuss, to look at options. You know, sometimes it is difficult to work around a request, but that's the whole point of flexible working, is that, you know, we find solutions where we can. And they found in this case that there were people that would have been able to cover some of her work, that 1 hour would not have been so critical, you know, that such to have turned her down and so on. So yeah, £185,000 later, she won that case. So changes to flexible working, you're going to need to look at your policies and make those amendments. The next one that I mentioned relates to redundancy protection, and that's being extended to protect women who are pregnant while they're on maternity leave, which is what we currently have, and then for a period when they return. And it will also, for the first time, protect people taking adoption leave and shared parental leave too. So as I said, under the current legislation, those parents on that kind of leave are only protected whilst they're on leave, not for a period after. And also the protection doesn't relate to during pregnancy. And the government did some research before this legislation and found that 77% of mothers said they had a negative or possibly discriminatory experience during pregnancy, maternity leave, and or on their return from maternity leave. So in terms of pregnancy, the new protection applies from the point an employee notifies their employer that they're pregnant on or after the 6th of April 2024. And the protection applies from the point of notification through the whole of their maternity leave and for a period after they return to work. It also protects someone if they suffer a miscarriage before the end of 24 weeks of pregnancy, and also stillbirths as well. So the existing protection is while on maternity leave, but that period of protection will now extend for 18 months after the expected week of childbirth. So if someone has 12 months of maternity leave, they will basically get another 6 months of protection when they return. So it's an 18-month period, but it will depend on when their expected week of confinement is, and so on. For adoption leave, the protection period ends 18 months after the child's placement of adoption. And there are rules related to shared parental leave, as long as someone has taken at least 6 consecutive weeks of shared parental leave, then they get that extension to protection as well. So quite a lot of change. If you're making redundancies and you have people that are on or pregnant, or so if they are on some of these different types of parental leave, if someone is pregnant, or if they've returned from some of those types of leave, you need to look at those dates and ensure that people aren't discriminated against in breach of this protection. And this is all about, the protection is all about failing to find suitable alternative employment for people who are protected in the way I've just described. So what the legislation requires is that these people are given alternative employment. Otherwise, you risk claims of automatic unfair dismissal and potentially unlawful discrimination. So you have to look really carefully across your vacancies, consider selection processes when you're making redundancies, and look at who the protected employees are to ensure that they are given available alternative employment over others. That's the whole point of the legislation. So if you're making redundancies, you have people in these categories, you need to look at what your alternatives are to make sure that they are given those alternative jobs if they're suitable. So the third one on my list of 4 was changes to paternity leave, and the new rules on paternity leave are changing again on the 6th of April. There's 3 changes. So people wanting to take paternity leave at the moment have to take either 1 week or 2 consecutive weeks. And the change will be that people can have 2 non-consecutive weeks if they wish to do so. So it's a minor change, but it does mean someone could take 1 week at one point and 1 week a little bit later. So that's the first change. The second one is a much bigger change. At the moment, paternity leave has to be taken within 56 days following the birth or adoption. The new legislation says it has to be taken within 52 weeks. So from 56 days to within 52 weeks. So a much larger time period. And then the last change is to the notice required to change dates. So at the moment, employees need to give 15 weeks notice of paternity leave dates before the expected week of birth. However, from the 6th of April, those who wish to take paternity leave will only have to give 28 days notice. So from 15 weeks to 28 days notice. So that's a big change. So again, these are coming in on the 6th of April. And then the last one I mentioned was the introduction of carers leave. So this is a new family-friendly leave obligation or right for people. So unpaid carers who are combining employment with looking after someone will have the legal right to 1 week's carers leave for the first time, again from the 6th of April. So this is an unpaid right. It's for a day one right. So you don't have to have a minimum amount of service with your employer to make your request for unpaid carers leave. It can be taken by employees who are providing or arranging care for a dependent with a long-term care need. And the Act defines long-term care as an illness or injury, physical or mental, that requires or is likely to require care of 3 months or longer. Or it may be something that is defined as a disability under the Equality Act, or if it's care related to old age. And the definition of dependent mirrors the definition we see elsewhere. For example, when we look at the right to time off for dependents. So this includes a spouse, a civil partner, a child, a parent, a person who lives in the same household, unless they're a tenant, lodger or boarder. And then there's the wider all catch-all provision that says, or any other person who reasonably relies on this person for care. And the regulations make clear that the entitlement to 1 week's leave is the maximum any employee could be entitled to, even if they've got more than one dependent. So it's not a week's leave per dependent, it's 1 week in total. Employers are not able to require an employee to give evidence of their entitlement to that leave. So I don't know whether this is a relief or not, but there's nothing in there that says that you have to have evidence to make your request. And given the challenges of managing sensitive personal or medical information that relate to a third party, that's probably sensible. The regulations also could have set out what particular activities are or are not to be classified as providing care, but they don't at the moment. So there don't appear to be any limitations. So I think it's a little bit left open to an employee to make an assessment as to whether or not they are providing or arranging care for a dependent. So it could include, excuse me, accompanying someone to medical appointments, helping someone with their financial affairs, providing actual personal care or medical care to someone. So it's not supposed to be for emergency time off. We've got dependents leave for that. This is for, arrangements that you're making. And you can take your leave as a week-long block, or you can take it as single days, or it says you can even take it as half days. So lots of flexibility. And when requesting leave, the employee will have to give twice the notice of the time they want, plus a day. So if they want 1 day off, they will have to give twice the notice, so 2 days plus a day, 3 days. So 3 days notice to get 1 day off. And so it's longer. So there's lots of prescriptive requirements in the legislation. We're all going to need a policy for this to add to the suite of other family-friendly policies. Employers also cannot deny someone the right. So when someone makes a request, you can't just simply say no. All you can do is postpone it if the operation of the business or work would be substantially disrupted for the days that the request is for. So you can postpone it, i.e. move the date if you can show substantial disruption, but you can't refuse it. And employees also cannot be penalised if they take this leave. It would be like any of the other automatic unfair dismissal claims that I told you about right at the beginning. So employees will be able to bring their unfair dismissal tribunal claims if there's unreasonable postponement or they've been excuse me, prevented from taking the leave or treated less favourably in some way. So there you go, carers leave, and that's definitely a new one that isn't an extension or a change from something that we already have. I think it makes sense, actually, before I start to look at the next change, which is July, for us to take our first break. So we've been going for about an hour. Let's take a 10-minute break, give you a chance to, make a cup of tea, have a quick comfort break, and I'll see you back here at 10 past, if that is good for everybody. So we'll have a short break and we'll continue at 10 past 10. Okay, thank you. Okay, everybody, hope you've managed to have a quick break and you're back with us. We had got to the 1st of July. So moving on in time, the change that will take place on the 1st of July relates to the transfer of undertakings requirements for small businesses. Excuse me. So from the 1st of July, businesses with fewer than 50 employees or for transfers involving fewer than 10 employees, they will be permitted to consult with affected employees directly and not undertake collective consultation as part of the transfer process, which is a requirement for either to consult with either existing union or employee representatives, or where no such representatives are already in a relevant body, then it requires the employer to enable the selection of representatives. So this change really aims to streamline those smaller transfer of undertaking issues. And this is the Transfer of Undertakings Protection of Employment Regulations. So the consultation rules are incredibly prescriptive. If any of you've been involved in that, you'll know just quite how many hoops have to be jumped through. So by law, both the incoming as well as the outgoing employer of whatever that group of employees are that are transferring, they must inform and consult during a TUPE transfer. And if an employer fails to inform or consult, they can be jointly or individually liable and taken to an employment tribunal by either the affected employees and or a recognised trade union if they've been refused consultation. And you'll have failed to inform and consult if you don't do it at all, or if you don't arrange the election for employee representatives to consult with, or if you didn't consult genuinely and meaningfully with representatives. And of course, if you have fewer than 10 employees, you didn't consult with them directly. So who pays the compensation? Well, either employees or trade unions can make a claim to a tribunal, and if they're successful, either employer could have to pay the penalty. So even if it was the other employer who failed to consult properly, that obligation, that liability can transfer to the new employer. And the penalty is up to 13 weeks gross uncapped pay per affected employee. So it's incredibly expensive to get this wrong. So if you're involved in any transfers of undertakings, you know, if part of your business is sold, or if the whole of your business moves to a new employer and the TUPE regulations apply, then there's lots to be done to ensure you don't fall foul of the transfer of undertakings protection of employment regulations. And this change only applies to those small cases, i.e. where there's less than 50 employees or the transfer involves fewer than 10 people. So watch out for those circumstances. And the second change we will have on the 1st of July relates to the allocation of tips to staff. And this has been floating around for a long time. I know I definitely mentioned it to you last year as something that should be on its way. And we now know it will be 1st of July. So this is where an employer will have a new obligation to ensure that 100% of employer received tips are paid to workers in full without deductions, and that the allocation is what the legislation describes as fair. And this duty is to ensure that all qualifying tips are allocated fairly to workers, including agency workers, according to their policy or practice. And again, we always find that there's draft statutory codes of practice that go with these legislation. And we have a draft code that was published back in December, just to help employers and workers understand the legislation and make sure that it gives fair allocation of tips to people. Now, the consultation on the code of practice closes, I think it closed yesterday, actually, either yesterday or today. And this is all about giving hospitality employers and workers proper tipping practices that are fair and transparent. My youngest son was most upset that this has only become law now, because he used to work in a restaurant while he was at college and moaned endlessly about the unfair allocation of tips. So this is different to directly employee received tips. So the employer has no control over tips that are given directly to an individual in cash. They're entitled to keep them for themselves or not, such as they wish to do. This is about employer received tips. So that's quite important. And under the draft code, which of course may be subject to some amendment given it's only just closed, the fundamental rules employers need to follow is that, firstly, 100% of tips and service charges must be distributed to staff, subject to usual tax deductions. And for the avoidance of doubt, employers will no longer be able to use tips or service charge money to cover administrative costs associated with the allocation of tips, such as payment for trunk systems or costs when a tip is paid on a credit card. So that's the first thing, 100% must be distributed. Payment of tips and service charges must be paid by the end of the following month in which they were paid by the consumer. So a tip payment made in January must be paid out by the end of February. So employers will no longer be able to store tips and pay them throughout the year, perhaps to cover, shortfalls or quiet seasons, or to pay them quarterly or any other similar arrangement. So they've got to be paid within a month of being received. And then tips and service charge payments must be paid to workers at the venue in which they were paid. So it's not possible to allocate tips between different sites. Tips must be allocated exclusively to the venue in which they were paid by the consumer. There is one slight exception to that, and that's for central services or staff that work remotely, like remote kitchen staff, for example. So the legislation does allow for that to be included in the distribution. I've mentioned it already, but agency workers are eligible for tips too. So the way in which agency workers are paid their tips will either be via the payroll or through the agency as the middle person. So the key point is that agency workers that work at that venue should not be excluded from that distribution. And finally, the distribution of tips and service charge payments must be fair. And the code of practice, or the draft code of practice, recognises that distributing tips fairly doesn't necessarily mean that employers have to allocate the same proportion to all workers. But where an employer decides to allocate tips in different proportions, they've got to set out clear objectives and factors that justify what that allocation is and demonstrate that it's fair and reasonable given the circumstances or nature of the business. So it might change according to type of role, how much somebody earns, personal performance or team performance. It could be related to length of time served. It could even be related to customer intention. So there might be lots of things to take into account of. But of course, if an employer is going to start paying different staff different proportions of tips, they're going to have to be careful to avoid any indirect or unintentional discrimination. If an employer decides to give more to front of house staff and more of those people have a particular protected characteristic, then are we looking at potentially a breach of the Equality Act? So it will need some careful consideration. And remember, employers may receive tips directly and pay their staff as part of the next payroll, or they might decide to distribute tips in a different way. So this is where the tronc systems come into effect, but there needs to be transparency. Oh, excuse me. So you're going to need a written policy. You're going to need to consult workers. You're going to need to keep a record of tips received and how they've been distributed. And in fact, the legislation says you've got to keep that record for 3 years from the date of receipt of the tip. So, of course, lots of rules, lots of bureaucracy, lots to think about. And it will be a case that people can take to the employment tribunal. So it will be a new type of complaint that we've not seen at the tribunal before. So if you are involved in businesses like that, or if you have a business like that, this is obviously a big change too. Okay, we're moving away from July and we're heading towards the autumn now. So from October this year, we will see the new Worker Protection Act come into effect. And this is where employers will have a positive duty to take reasonable steps to prevent sexual harassment from the workplace. Now, this new legislation only references sexual harassment. That doesn't mean to say other types of harassment you don't have to, ensure that you deal with appropriately, but this is a duty to prevent rather than redress. So this means employers have a proactive obligation to ensure the prevention of sexual harassment at work, and that it's a greater obligation basically and responsibility to make workplaces safe for all staff and free from sexual harassment. So what should an employer do? Employers should ensure that they have clear anti-sexual harassment policies in place and review and update, equality, dignity at work policies too, and recirculate them. It's all very well updating policies, but if people don't see them, they're of little use. So recirculate, educate people as to what they are, and be clear about what is an acceptable type of behaviour and what isn't. And this is why we see so many banter cases go wrong, because people just don't know what is and isn't okay, and make assumptions or think, well, I wouldn't be offended by that, so therefore it must be all right. So I think the more easy explanations we give for what is acceptable and what is not, the better it will be. We also need to make sure people know how to, apart from what's expected of them, how to address such behaviour, whether it's informally or formally, and raise awareness of how people make complaint and the protection available to them. I do lots and lots of this type of training. It's probably the most common type of training I do: equality, diversity, and inclusion. And I always make sure on my courses that I include a section about how to say if something makes you feel uncomfortable, or you're not okay, or you're not happy with something that's been said or done. Because so often, if it was said at the time and someone understood where they'd gone wrong and, accepted that feedback for the valuable, way it was intended, so many issues would just be nipped in the bud right at the beginning. So I think people have to know how to say something, and then when something is said, know how to receive that feedback and make the right changes. So it's not just for me about formal complaints, it's also how to deal with it conversationally and informally, and how to be a bystander, how to stand up for colleagues, how to intervene when there's an issue. And the active bystander training courses that I do and lots of other people do, I think are really valuable for that. It's a lot easier to spot someone else's bad behaviour than it is sometimes to spot where we're going wrong. So if we can help each other out, as by being an active bystander, I think that's a really helpful, compassionate thing to do as well. So regular training is really important, that people understand, what it is, what the dangers are, what to make sure we don't do. Case law has demonstrated time and time again that if training is stale, if it's a tick box, e-learning, get to the end, answer 6 questions, hurrah, you've been trained, that's unlikely to meet the reasonable steps defence required to defend yourself against a sexual harassment claim. So it remains to be seen what there will be in terms of expectations of employers, but good policies that are known to people, and good quality training has got to be essential steps for most people. Then when you get a complaint, we need to jump on that issue and deal with it in a timely fashion, effectively, proper investigations, support for people, follow up, and put in place, if you haven't done so already, I think a reporting register is a good idea for complaints about all forms of harassment, so they can be tracked. You can look for trends, you can look for repeat types of issue or repeat offenders, and give you an opportunity to get ahead of and deal with difficult issues. So obviously that's got to be kept entirely private, and access should be limited as to who sees that. But I think when you've got a big organisation in particular, where different people, lots of HR teams, dealing with things in different ways, often there is no central resource like that. And I think it's really helpful to have that. So watch out for this one. It's definitely coming in October, and we'll probably see more attention paid to trying to eliminate this kind of problem from the workplace. The next right is for workers to request a more predictable work pattern. Now, we don't have a date for this. I did look yesterday and couldn't see a date. It's always been announced that it will be September, October time, 2024. So even though there is no date, I want to mention it to you so you're aware of it. So this is called the Workers, open brackets, Predictable Terms and Conditions, close brackets, Act. And it will give workers and agency workers the right to request more predictable patterns of working and terms and conditions of work. So it's really useful where there's a real lack of predictability. So people on 0 hours, on fixed term contracts of 12 months or less. A minimum service requirement is expected to be 26 weeks. So it's not a day one right to request a more predictable work pattern. You'd have to have 6 months service to make the request. And employers will be told to deal with the request in a reasonable manner. We're back to that word, reasonable. And what does that mean? And also they will have to notify the worker of their decision within a month. So not too long a period, as we do sometimes see in other obligations. And it will also be possible to make 2 applications in a 12-month period. And applications can be rejected on a number of statutory grounds. So in many ways, it reflects what we're used to with flexible working requests. So workers can make claims to the tribunal. Again, this will be a new matter for tribunals to deal with. And it's likely to be procedural failings or unlawful detriment, or even people being dismissed if they make those predictable working requests. So ACAS have just finished consulting on a new statutory code of practice. I think that was just towards the end of January. So I think that will be out soon too, and should give a bit more information as to the practicalities of dealing with these requests. So that's the Predictable Terms and Conditions Act. So that brings us to the end of the new legislation for this year. And as you can see, there's quite a lot coming in. So perhaps quite a bit of change to be made in some workplaces. On top of that, every year, as you know, I cover this every year, we have the normal changes to statutory sums to deal with as well. So I'm going to run through what they are to you, as this is very timely. So we've got from the 1st of April changes to the national minimum wages and the national living wage. And I think this slide sets it out relatively clearly as to what's happening. It's exactly 25 years now since the National Minimum Wage Act was introduced. And back then, the headline hourly rate, it was for adults aged 22 and over, then was £3.60. So it's changed a little bit, and also the age has changed. So it went from 22 down to 21. And now we see that it will be £11.44. And with that change, the national minimum wage will have risen to the level of 2/3 of the median hourly pay rate, and clearly well above where it was in April 1999. So for workers aged 21 and over, the rate is increasing by £1.02. And there's various changes, as you can see, throughout the age ranges. And also there's a change on the 1st of April for live-in domestic workers, including people like nannies and au pairs. So they will be entitled for the first time to the national minimum wage too. So that's a big change for that category of worker or employee. And we've just seen the Department for Business and Trade publish, and it literally was a few days ago, their list of employers who have fallen foul of not paying the national minimum wage. And this time we saw, you know, household names like Greggs and EasyJet and River Island, lots of very recognisable employers named by the government as having failed to pay the national minimum wage to some of their workers. In fact, there were 524 employers on the list, and collectively 172,000 workers were out of pocket by £16 million, because a lot of the backdates were for a number of years. And the businesses on the list, I understand, have all since paid back what they owed, and many of it is mistakes and misunderstandings about certain parts of the national minimum wage legislation, rather than purposeful, terrible paying too low a rate. But there you go, lots of employers, lots of people, lots of change. And I think underpayment remains a massive problem still, which, you know, you'd think after 25 years, we'd be on top of it, but there you go. So that's the changes to the national minimum wage. So here's your next question. So if I'm paid my annual bonus before my maternity leave starts, does that increase my maternity pay, or is basic pay used as the statutory maternity pay calculation? So does that bonus is that bonus taken into account as to how much maternity pay I should receive, or do we look at what someone's basic pay should be? So choice of 2 for you this time. Oh, pretty even split. So just, excuse me, I really have a frog in my throat today. 43% of you say it does increase maternity pay, but the majority say it doesn't, and it's basic pay that's used in the calculation. Well, this time the majority don't have it. And in fact, that 43% is the correct group because it does increase maternity pay. So if an employer pays a bonus, and it doesn't matter what that bonus is for, and it has to be paid in the 8-week reference period that is used to calculate statutory maternity pay, then it will increase, and dramatically in some cases increase, how much maternity pay is to be paid. And I work with an employer who has someone on maternity leave who earned a 50% salary of their salary bonus in the 8-week reference period. Now imagine what a difference that made. So if you qualify for statutory maternity pay, it's paid for a maximum of 39 weeks, and the first 6 weeks are at 90% of average gross weekly earnings with no upper limit, and the remaining 33 weeks are paid at the new rate, which is £184.03. I think I've put that on the next slide. Yes, there we go. So yeah, the amount of statutory maternity pay that an employee will receive is based on this 8-week reference period, which is the 8 weeks that ends on the qualifying week, and the qualifying week is the 15th week before the expected week of confinement. So it's the 8 weeks prior to the 15th week before the expected week of confinement. It can include overtime, commission, bonuses, back pay. You know, it's because you look at what they've received. So a woman's SMP entitlement can be significantly increased if annual bonuses are paid during that period. Even if it's discretionary, even if it relates not to something that person has done, it's a company-based payment, it doesn't make any difference. The law says if the payments are derived from employment, and all payments are, then it should be calculated. Also, we've got to make sure that we don't exclude people from any pay rises. So pay rises shouldn't be withheld because someone is on maternity leave or absent for some other family-friendly related leave. But remember, their remuneration is replaced by statutory maternity pay. So it can affect the receipt of, you know, if there's an annual bonus payable whilst they're on maternity leave, so it doesn't affect their maternity pay, but they would be due it, then you can make certain deductions for their absence. But, you know, again, the legislation sets out quite clearly how you should deal with those kind of payments. Also, if an employee receives a pay rise at any time between the start of their maternity pay calculation period, so the start of that 8 weeks, and the end of their maternity leave, then how much more they're earning should also go into the recalculating the maternity pay they've received, even if it isn't backdated. So it's quite strange legislation in a way. It's very prescriptive. So any pay rise given at any point between the start of that 8-week reference period and the end of maternity leave has to then factor a recalculation of what their maternity pay was, and you pay any extra. So lots of rules. Okay, the next one that we know about is statutory sick pay. And that will go up on the 8th of April, and it will go up to £116.75. We haven't yet to hear, though, what will happen to redundancy pay. So there's still not been an announcement, and normally that's an April change as well. So all I can give you is the current rate, which is 643. So the maximum total redundancy pay is still £19,290 if you've got more than 20 years of service, and all those 20 years are in the upper age category. Remember, with redundancy pay, you have to have 2 years minimum service to get any redundancy pay at all. And it's only the last 20 years of your employment that goes into the calculation. So you get more according to how old you are. It's one of those age discrimination issues that's allowable by our legislation. So at the moment, we don't know what the new figure will be. I'm sure it will be announced shortly. The other one that we haven't been advised about is what changes there will be to the maximum compensatory award at the Employment Tribunal. So it remains the lesser of either 52 weeks gross pay or £105,707. So if you earn more than 105,707, you're stuck with that cap. If you earn less than that figure, the maximum you will get is 52 weeks of your gross pay. So again, I expect it will change shortly, and we'll hear what the new figures are. And successful claimants get an award that includes a basic award, which is calculated in exactly the same way as redundancy pay is calculated. And then on top of that, they get a compensatory award, which is their loss of earnings before they're able to have sought alternative employment. So there's 2 parts to an unfair dismissal compensatory payment. Basic award, same as statutory redundancy, and then compensatory award, which is about lost earnings. So we still need to wait for that one. And the last one that we haven't yet heard is what changes there may be to the Vento bans. And this is compensation payments that are only related to discrimination claims. These are the 2023 rates. So the purpose of this is to make an injury to feelings payment. So with discrimination, you get the basic award I've just spoken to you about, the compensatory award, and also an injury to feelings payment, but that's only on discrimination cases. So it's there to compensate someone for the hurt and humiliation and distress that they've suffered, rather than as a punishment to the employer or person held responsible for whatever the discriminatory conduct was. And in discrimination cases, it's probably worth a reminder that there is personal liability as well as organisational liability. So when people bring claims against their employer for discrimination, they normally now claim against the employer as the first respondent, and then whatever individual did whatever the acts of discrimination or harassment were as personally named respondents. And if an employer has taken all reasonable steps to eliminate discrimination, and they can show, they've got great policies and everybody knows about them, and we remind people regularly, and we do great training, and we're really clear about what is and isn't acceptable, and we deal with issues really well and in a really timely fashion. If an employer can tick all those boxes, then they may be able to say, why should we be liable for the rogue acts of this employee that's doing things that we tell them not to do? We should not be liable for that. And then the liability could move to being one that the organisation may have to deal with, to one that the individual will have to deal with personally. It's quite important for lots of reasons that we try and eliminate discrimination from our workplaces. But I often find when people realise that it's an area for personal liability, that stops people and makes them listen to, what the training is and what the obligations are. But as to how much somebody be awarded, I mean, it's completely case dependent, obviously, as I'm sure you would appreciate. There was a case a while back where a demeaning comment was made to a youngish employee, and they were told that they were a spoilt child, which was followed by a prompt apology. but they were still awarded with £1,000. The bands were lower when this case came out. So a one-off single act, including an apology, was still awarded with an injury to feelings payment of £1,000. And then you get other cases on the other end of the spectrum where people have lengthy campaigns of behaviour. It causes them to lose their job. It causes a great deal of distress and upset. And then you could see yourself at the other end of that scale. So I don't know what the new rates will be yet. Okay, I want to now mention a few more bits of case law that's recent. I always try and have a section when we look at recent case law or interesting or relevant to lots of organisations. So we'll cover off a few of those next. But first, I've got a question for you. So, is it true or false? Is this statement true or false? A woman should not be contacted once she starts her maternity leave. So is that true or false? Easy 50-50 choice for this one. Here we go. So 22% of you believe it's true. She shouldn't be contacted once she starts her maternity leave, and 78% say false. And the majority, we're back to the majority wins, and it's correct. It's false. You can contact someone on maternity leave. So there's a number of reasons that you might want to contact someone. First of all, there is up to 10 days keep in touch days available for people to use in maternity leave. So you would not be able to offer that to somebody without contacting them. This might be if you've got a team, away day or some team training, or there's a particularly interesting piece of work that person might be interested in doing. So you can suggest keep in touch days. The individual can also suggest keep in touch days, but there's got to be contact for that to happen. If you've got an annual review, we've been talking about pay rises, and people would normally have an opportunity to have a meeting to discuss that, then you should still offer someone on maternity leave the chance to have that meeting, should they wish to do so. If you've got a TUPE situation, the Transfer of Undertakings Protection of Employment, if you've got a redundancy situation and you need to consult, then you should still consult or include people on maternity leave or other family-friendly leave. And any other contact that if you didn't make that contact, there's potential for a detriment or someone feeling less favourably treated. But of course, the one thing you shouldn't do is expect someone to work or harass someone. So if you kept ringing someone saying, oh, where's that file? Or could you tell me what work was done with such and such client? Or could you just quickly look at this for me and let me know X, Y, and Z? Of course, that's not appropriate. And pregnancy and maternity, as I showed you earlier, is of course one of the 9 protected characteristics, and it's unique because it's protection for women only. So reasonable contact is certainly permitted as long as it doesn't harass or doesn't fall into unreasonable contact. Okay, good. So the reason I wanted to mention this is because we've had this quite interesting recent case, Ladd versus Lilyhead Dental Practice Sales Limited. And this for me was a real stark reminder of the kind of potential legal minefield that accompanies the management of digital communications in professional settings. So this is a case where a female staff was removed from a WhatsApp group, a work WhatsApp group, while they were on maternity leave. And that was found to be an act of discrimination by the tribunal after the mother concerned sued the dental firm, claiming that she felt isolated when her boss refused to put her back into the chat. They are yet to decide how much compensation she should receive. I doubt it's going to be a really high earning case. However, defending cases is really expensive, whether you win or lose. So I think the takeaway here is, I mean, it really shows the nuances of the legal position. Originally, she was removed from the WhatsApp group and she was told, we'll take you off, but if ever you want to go back in, just let us know. So probably nothing wrong there, although I would probably suggest you ask if they want to stay on it rather than remove them and say, tell me if you want to come back. However, no issue there. The issue arose when she lost her work phone and requested a replacement. And at the same time as requesting the replacement, she asked to be put back into the WhatsApp group. Her employer refused. They both refused to replace the phone at that point in time, and obviously refused to allow her to re-access the WhatsApp group. So that's where she won her case. So I think it's it's an interesting one to think about. What steps do we take when people take this either maternity leave or other leave to make sure that there's no detriment and people are no worse off for the time off, no less favourable treatment. Very similarly is another case from the last 12 months, more danger points here. This is Smith versus Greatwell Homes Limited, a part office worker who was excluded from a company-wide free day off, additional day off. And also she was not sent internal job adverts while she was on maternity leave, even though she had been actively applying for promotional positions before she'd informed her employer that she was pregnant. And the employer found both of these things to be acts of discrimination, and she was awarded £50,000 in compensation. And in this case, the staff were all given this free additional day off as a thank you for all their hard work and efforts. And it was to be taken on a Friday. However, she mentioned that she didn't work Fridays, but the firm refused to allow her to take a different day off. It just seems to me an incredible decision, but there you go, that's what they did. They didn't allow her to reschedule that, and so that becomes unfavourable part-time workers discrimination. And as more women than men work part-time, it's sex discrimination. The second part of her claim was that while on maternity leave, she received a text message from the HR team that told her that she had a new manager. The firm had appointed a new manager, and they had also hired into another managerial role. Now, these were only published internally on the company intranet, and these were both roles that the tribunal later ruled that she would have been able to progress to within the company. And as she wasn't happy about these decisions and the lack of communication and ability to apply during her maternity leave, it became matters that she complained of by way of discrimination. So quite expensive, £50,000 in compensation. It reminds me of another quite similar case years ago, 2004, which is Paul versus Visa International. And this was similar in that Mrs. Paul was interested in moving internally within Visa. She'd had discussions about that with her manager. She's then pregnant. She's then on maternity leave. She doesn't get to see a vacancy. It's filled and she doesn't have the chance to apply. Now, she resigned as a result of that and brought a claim of constructive unfair dismissal and discrimination. And she was awarded £26,000, which was back in 2004, a long time ago. And the interesting point on this case was that she said she may not have even applied, and she accepts she may not have been successful, but what she lost was the chance, the opportunity. So the compensation was for the loss of the chance in that case. So really important that we think about people when they're off, have discussions before maternity leave starts. I certainly tell clients to always put it in their letter. So you have to write to someone before their maternity leave begins, setting out, you know, when they're going to start, when they're going to return, what's happening with their leave, how much money they're going to get paid, all those kind of things. That's a legal obligation to put all that in writing. And that's the place to put it. You know, what would you like to know about? What vacancies would you be interested in? Will you retain access to our intranet where our vacancies are posted? You know, just cover it off in writing and make sure that people aren't less favourably treated. But a good reminder there to, you know, it's often we're out of sight, out of mind, and we need to make sure that that isn't the case. Next is a work from home tribunal case. So, and actually, as we're nearly on the hour, I think this is a good time to stop before because this is quite an interesting case as well, because so many employers are now asking people who have maybe been working from home for quite a long time or had, you know, real flexibility and, you know, the ability to have some remote working. Many employers are asking people to come back into the office full time. So I think this is a really relevant case to think about. So let's take another short comfort break. It's about 5 to. Let's be back again at 10 past. I'll give you slightly longer to make sure you have a decent amount of time away from your computer. And I'll see you back here at 10 past and we'll talk about the last few cases and then what's to come in the future then. Okay, thank you very much. Right, welcome back, everybody. I thought it might be a good idea just to pick up on some of the questions before we carry on. So, got one question, which is, would it be acceptable or lawful to contractually oblige an employee who receives a personal tip to place this in the general pot? So that's an interesting question. I think contractually, I don't see any reason why you wouldn't be able to require somebody to do that. You can require, I've seen it in a contract, requiring employees to disclose what tips they've received. So I don't see why you wouldn't be able to contractually require them to pool any tips received. Policing it might be more difficult, but I don't see why you shouldn't be able to do that. The next one was, are hospital doctors unique in getting paid while on strike? And if so, presumably this is provided for in their contracts. Well, my understanding was that junior doctors didn't get paid when they were on strike. And I'm sure I read somewhere that it said there's so far been 28 days of strike and 28 days loss of pay. So I guess if there was a contract that allowed for payment whilst on strike, then you would see that, but it's pretty unusual. I mean, normally that's one of the ways an employer dissuades people from taking strike action is the loss of pay. I know in the Quorn strike I told you about earlier, the union in that strike paid 60% of their basic wage while they were on strike. So they had a strike fund in the union, but I don't believe that the junior doctors had that. But if they did, then it would, you're right, it would be contractual. The next question was, what about service charges paid to restaurant? Is this classified as tips? It's a really good question. And service charges are included as an extra payment or monetary amount on a customer's bill. And even though service charges aren't classically charged out as tips, the new tip sharing laws requires that they be divided between employees and workers as well. So yes. Then is there a link to the new rules and to tips? I would say the best place to go is .gov.uk. If you put that into your search engine and look for the gov.uk response that comes up, that will give you the direct link to the legislation. So either good places for good information, ACAS, and .gov.uk. Thank you. And then finally, there was one last question. Oh, yeah. Bonus. Does it matter if the bonus is a one-off? And I think that relates to the maternity calculation. And no, it wouldn't matter. So it's anything that's paid within that 8-week period where you work out how much maternity pay you pay someone goes into the calculation. Brilliant. Thank you very much. Great questions. So let's go back to where we were, which is Wilson and Financial Conduct Authority, this tribunal case. So this was where Mrs. Wilson submitted a flexible working request because she wanted to continue working remotely every day as she had been since COVID. And she argued that she was a high performer and she continued to be a high performer and it had no impact. So in early March, this is a recent case, March 2023, she learnt that her request had been refused. And in the letter, her manager said, I recognise that you've performed really well during the period that you've worked from home and you've got and built effective relationships with colleagues despite not meeting them in person. However, I'm turning down your request because it does have a detrimental impact on performance and quality of output. So she was told that would include the fact that she missed out on face-to-face training sessions and they weren't as effective when they were mixed. I must admit, I find it quite difficult to do training when I'm in person with half the group and then there's people remotely dialing in because it's so easy to forget that they're there if your back is to a screen. But anyway, so that was one of the reasons that she would miss out on departmental away days and team meetings, that she wouldn't be able to coach effectively new team members, and so on. So there are a number of reasons that was turned down. And also it included your ability to input to management strategy meetings that are often last minute and involve in-person collaboration is also a negative effect. So she was turned down, she lodged an appeal, but that too was rejected on the same or similar grounds. So off she went to the tribunal. And in the judgment of this tribunal, it was said that it's the experience of many who work using technology that is not as well suited to the fast-paced interplay of exchanges that occur in a face-to-face, planning meeting or training course, or, where you pass people in a corridor and you pick up on a topic. And that if that was good business reason, then it would and could be reason to turn down someone's request. And the judge added that it would not be incorrect for her manager to have identified these as potential risks to performance, even though, performance had been acceptable or good whilst working from home. So this is, as far as I know, the first tribunal case to consider employees' rights and expectations around remote working since the pandemic. And as I said earlier, so many employers are now invoking the kind of right to come back to work and setting out policies and requiring people with notice to return to the office. I think we'll see more and more of these. I think what you need to consider is, like I say to everybody, first place to always look is what's in the employment contract. So check what is the place of work stated in the contract. If it's set out as the office, then you're in a much stronger position to require, with some reasonable notice, that someone return back to do as contractually required. If someone then fails to do so, you've got good argument that they have failed to comply with a reasonable management instruction. And similarly, if you've got a mobility clause, then you invoke that because that will allow you to invoke change. Remember the Equality Act obligations, though. If someone is working from home related to a health issue, related to any of those protected characteristics, then of course we need to give proper and full consideration to those kind of requests, or we risk disability discrimination, or discrimination on the grounds of failing to undertake a reasonable adjustment for somebody with a disability. So particularly relevant in sex discrimination cases as well as disability discrimination. It could result in unfair dismissal. If someone says, I cannot return to work and I will have to leave, and I think your requirement to have me do so is, unreasonable, then you could be left with defending a constructive unfair dismissal case. Of course, if you require someone to come back to work, they have the right to make a flexible working request, which we talked about earlier. So at the moment, they need 26 weeks service, but not for long. And remember, they can make more than one request a year now, they can make 2. So if someone doesn't comply, they can make a flexible working request. You get more difficulties if people have moved away or got a pet. There's lots of change that took place during lengthy periods of people starting to work from home. So good consultation, proper notice to make arrangements is quite important. So lots to think about, but this set out that there can be fair reasons and, fair process is required, and then people can be obliged in some circumstances to return to the office. Okay, another question for you now. So, can you negotiate a deal with an employee to settle a future claim which hasn't yet arisen? So, can you, in a settlement agreement, negotiate a deal that also settles claims you don't even know they may have, future claims? So, it's an easy choice again here with a yes or no. Minute to complete. Here we go then. So yes, 40% of you think you are able to settle future claims which haven't yet arisen, and 60% of you say you can't. So if not an even split, but not far off. So thank you for that. The answer for this question comes with my next case I want to tell you about. And I'll give you the answer at the end of the explanation. So, settlement agreements. These are documents utilised to help manage an exit process. When an employee leaves their place of employment, in a redundancy or a dismissal situation, by signing a settlement agreement, the employee agrees to waive all their rights, legal rights, to pursue claims against their employer. And in exchange for that agreement, a financial sum is made. So that's what a settlement agreement is all about. Employees presented with a settlement agreement will often be aware of what the potential claims are that they could bring against the employer. And the reason that they're aware is that settlement agreements have to be signed by a lawyer. So you get advice. If you're presented with a settlement agreement, you take advice, you pay for your advice, and you're told what you're signing away in exchange for what the sum of money is. But the question I posed was, can you have a catch-all that also protects you from future claims or claims you don't know about? And in this case, Bathgate, it's a Scottish Court of Session case in Scotland. And this employee had 20 years of service and accepted a voluntary redundancy and signed a settlement agreement. And in that settlement agreement, it included a waiver clause settling all employee claims against the company. And that included age discrimination. It was a broad, all claims including, and it listed age discrimination as one of them. So the terms of the standard settlement agreement included an additional payment to the employee because of that. And there was an issue about a payment that should have been made if someone was under the age of 61, some contractual clause. This person was over the age of 61, so there was no obligation to make this payment. However, the employee was disgruntled and thought that they were entitled to it. And so they brought a claim of age-related discrimination. This was defended, however, on the terms of the settlement agreement, which settled any claims that the employee may be able to bring against the employer. So it goes to the employment tribunal, and they agree with the company's argument and say, you don't have to pay it, you've settled all claims, known or not known. It goes on appeal. So off it goes to the Employment Appeal Tribunal, who decide the opposite and say, well, you can't settle claims that you don't yet know about, future claims. They can't be waived. So reverses the decision. Now the company is dissatisfied with the outcome, so they appeal to the Court of Session, which is the same as the Court of as the Supreme Civil Court. And they say that the Equality Act should not prevent settlement of claims unknown to the parties at the time the agreement was signed. However, we don't yet have a decision from this court. So we are now waiting to see whether they will go with the first judgment, which is that you can't settle everything, or with the second judgment, where you, sorry, it's the other way around, where you can, and then second judgment, which says that you can't. So I will have to tell you next time what the result of this was. It's fundamentally important, this, because there are so many settlement claims made, and the ability to settle all and any claim will make a big difference to drafting. I mean, it just goes back to how important drafting is, actually, and how important it is to take advice, especially with this kind of case. Good. So I just wanted to mention what the alternative to a settlement agreement is. So settlement agreements, as I've explained, you have to take advice and they have to be signed by advisors. The alternative is something called a COT3, and this is a document managed by ACAS. It's also a written agreement, and it also intends to settle and resolve potential employment law complaints that have been brought or potentially could be brought in an employment tribunal or court by employees or workers. And again, it's in exchange for financial compensation. The key difference between the two is that a COT3 is far more concise. It's a short, simple document, and it's free from any cost because ACAS is a free service and they will draft it. So it is an alternative, especially if cost is an issue, to contact ACAS. And in order to encourage people to discuss freely exits, the law allows in some circumstances for employers and employees to have protected conversations. And this means that you can negotiate freely without fear that it will be used against you. These conversations should not only be protected by that legislation, but they should also be termed as without prejudice and subject to contract as well. So it's really important, if you're going to have conversation with people about them leaving, that you script them so they will comply with the protected conversation obligation without prejudice and subject to contract as well. Get a script and follow the script, take some advice. And employees can raise a request for a settlement agreement as well as employers. In fact, someone I know quite well did this recently. He was in a very senior job, didn't want to continue to work with the chief exec and the chairman, and decided to find another job and then try and negotiate an exit. But obviously didn't tell his employer that he'd lined up another job. So he approaches, asks for if they're interested in having a protected conversation, says he's not happy. Turns out they weren't happy with him either, and they decide to give him a settlement agreement, and it was substantial, and he signed the agreement, took the money and walked straight into another job. So I often say to clients, if someone approaches you for a settlement agreement, think really carefully about whether you want to do that, because often they will have found another job first. You can put clauses into settlement agreements about that, so it's not impossible to do that, but just think carefully, think twice. Okay, then we've got a fire and rehire case. Now, this is brought by Union and Employees Against Tesco's Stores Limited. And the fire rehire practice is one that HR people are quite familiar with, and lawyers obviously too. And this is a business practice where an employer will dismiss workers with notice and then immediately re-engage them with different contractual terms or working conditions. So basically, it's kind of a two-letter process. There has to be some sufficient business issue that requires termination of employment. There has to be proper consultation. And then if agreement can't be sought, then the last step after all that, those fair processes, is to say, well, we want to impose it, so I'm going to terminate your employment with notice. But at the same time, I'm offering you a job back with continuous employment, but on the new terms. So hence the fire rehire title. So the question here is, when is something permanent and when is it not? And this is another lesson in detail and drafting. So the challenge faced in this case was Tesco's took a decision to fire and rehire a group of employees in order to change their contractual terms. And what they wanted to do from this group is remove a payment called retained pay. So a number of years ago, retained pay was an incentive that Tesco's agreed to pay to keep a certain group of people in employment. And it was right back in 2007. So they agreed this monthly incentive payment for this group back in 2007. And they, in exchange for no redundancies and to accommodate relocations, there were all sorts of things that went with it. And the entitlement was negotiated as a permanent change intended to last for as long as the employee remained in role. So that was what the agreement was intended. The understanding was that it was guaranteed for life, essentially, and therefore permanent. And the collective agreement guaranteed this incentive for the duration of the contracts of employment for those people. Now, what's happened here is that Tesco's have decided that they want to stop those contracts of employment and issue new ones instead. So it's all going to come down to, should that be allowable or should the retained pay continue? It's really interesting. Well, it will be a really interesting decision when we get to hear about it. So we're still waiting for the Court of Appeal. No, sorry, it's gone further. It's gone now to the Supreme Court. So we're waiting to see whether they will agree with the Court of Appeal or not, and whether this will be a permanent change and therefore that Tesco's cannot end the contracts. The difficulty is the contract has a clause to end it. And what Tesco's are saying is, we want to invoke the clause that exists to end this contract, and we will offer new contracts. And it's for the duration of the contract, not for the duration of employment. So it's a technical point, but we will wait and see what happens. It will be interesting as to whether that is a decision that goes in favour of the employees, or it's back to buyer beware. You know, you've got to be super clear, and we'll go against Tesco's. Okay, so lastly, on the cases to update you about recent cases is this last case. And this is all about a geography teacher who was dismissed while he was off on work-related stress and sick and absent from work. So two issues here. He was dismissed while he was off sick, and he was also given a really damning reference later. So his lessons as a geography teacher were monitored as part of a standard review process for this school. So someone observed him teaching and made some positive observations, as well as some constructive criticisms. And this resulted in a suggestion that he received some informal support to aid his performance for a period of 6 weeks. However, he took great offence at this and did not attend the first meeting set out for this informal support plan. he was really defensive, rejected the constructive criticisms and said he was offended. He considered himself to be a leader within the school in terms of teaching practice, so he refused. He then raised a formal grievance about it, and within a matter of days, he went off on sick leave for work-related stress. He didn't come back to work for a long time. The school closed for the summer holidays, and at the start of September, a new term, he was asked if he was willing to engage in the process, and he said he was not. So he commenced a further period of sickness absence and handed in a doctor's fit note that said he was to rest. Now, attempts were made to move this situation forward. He remained off sick until the following January, so this is lengthy time off. And even at that point, the tribunal heard he was still being very uncooperative and refused to attend scheduled meetings with the head teacher. Signed off sick again, signed off until he was eventually dismissed the following July. During that period, he filed more grievances and there was more difficulty. A reconciliation meeting was arranged, but he was off sick. It was suggested that he could return to work early, but he said he didn't want to. Lots of difficulty. Anyway, following this attempted meeting, he wrote to the head and threatened her with legal proceedings and said that he would go back to his GP to be signed off for a further period if he wasn't able to return to work. To cut a very long story short, the school decided to terminate his employment whilst he was off on this last GP fit note. However, they terminated his employment on the 8th of July and the fit note expired on the 12th of July. And of course, he argued, I would have returned to work. Now, you have to be super careful when you dismiss people that have been off on long-term sick, because if their fit note is about to expire, you wouldn't take the risk of them coming back to work at that point. This is where proper meetings and consultation and up-to-date medical information and even, seeing occupational health therapists is all really important steps and stages to take. So he brought an unfair dismissal claim. Following this, he applied and he won. And he also applied for a role at a different school. And he claimed that he didn't get it because of a reference that was full of negative comments from this head teacher who had obviously had enough of him. So the tribunal determined that he was unfairly dismissed by the school's handling of their formal processes and the failure to wait those last few days before making a decision. So that was a procedurally unfair dismissal. And every dismissal is judged in two ways. Is it procedurally fair and is it substantively fair? Substantively means, should someone be dismissed for this reason? Procedural means, did the right processes take place? So every dismissal is judged on both categories, if you like. So it was procedurally unfair. I'm pretty sure had they waited, it would have been fair, and carried out a fair procedure. That would have been a fair dismissal, given the amount of time off. He was also not given a final warning that said, if you don't return at the end of your next, fit notes expiry, we'll be looking to terminate your employment. So there was no kind of clear warning either. As for the reference, apparently the head failed to adequately explain her decision to answer no to the question of, is this person honest and trustworthy? So that's the question. And the head says, no, they're not. And because of that, he was able to bring a victimisation complaint, and that too was successful. So lots of lessons here, mostly about process and procedure, but also about, references need to be fair and accurate and not misleading. And, whether there was any evidence of dishonesty and not being trustworthy, answering no without backing that up is always going to be a difficulty. Good. So we're on to our last little mini section now, which is and what's next. So what might happen in 2025? Well, we know that we are going to see the Neonatal Care, open brackets, Leave and Pay, close brackets, Act coming in. So it's expected that the neonatal right will come in April 2025 and will apply to parents of newborn babies who are up to the age of 28 days, who are hospitalised and need neonatal care for a continuous period of 7 days or more. And if someone falls into that category, those have those circumstances, then they will be eligible for neonatal leave and pay for up to 12 weeks. So this will allow parents to spend more time with their babies who are having specialist care without the worry of having to take unpaid leave or being, feeling obliged to return to work. So it's a really important right for people. Parents who take neonatal leave and pay, and it's expected to be paid at the statutory rate that we're used to for other, for statutory maternity pay, for example, they will also have the right to return to their job at the end of that period of absence. It's going to be a day one right, so no minimum service required beforehand. And obviously they'll have the right not to be discriminated against or unfairly treated or suffer a detriment because they've taken that time off. So lots of rules, and hopefully we'll have much more certainty soon about when this is coming in. And I read recently Tesco's again, who have introduced a raft of new family-friendly policies, and it includes something called paid kinship leave. And this is for employees responsible for caring for relatives' children. This isn't legislation, this is something that they've decided to do. So that's the first one on me. I had not heard of an employer doing that. So paid kinship. I've heard of employers give ovulation leave, and I've heard employers who give paternity leave. Paw as in doggy paw, so paternity leave, but paid kinship was a new one. Anyway, great and really helpful, I'm sure. So this will go down with all the other family-friendly rights that we already have. And there's the list. So we'll be adding carers leave, which I talked to you about earlier, coming in this year, and neonatal leave and pay coming in next year. So a few more changes to support people in these areas. Okay, then some of you may remember a few years ago that hearing fees were introduced at the Employment Tribunal and at the Employment Appeal Tribunal. And that was back in 2013. So it was always free to bring a claim. And then in 2013, the government introduced a fees regime, and people were paying upwards of, I'm trying to think what it was, I think it was about £1,200 for some claims, between £400 and £1,200, depending on the type of claim, and employment appeal costs were even higher than that. So it was very expensive. And that lasted from 2013 to 2017, when the Supreme Court decided that it was unlawful to have brought fees in because it interfered with access to justice and was also discriminatory against women who earn less and were less able to, or less favourably treated because of that fees regime. So it was abolished and all the fees were paid back. And then I read on the 29th of January this year, the government has launched a consultation payment to reintroduce fees, so bring fees back. Although notably, the big difference this time is it's far more affordable. So it will be a modest £55 to bring an employment tribunal claim and a further £55 to bring an employment appeal tribunal claim. And there will still be some exceptions to this for those that, generally can't afford that, which there was before. Let's see how that consultation paper goes. One of the big arguments at the time was it's just far too much money, and had it have been far less, and you have to pay in most other court cases, then it would be an acceptable addition. So we'll wait and see. There are obviously people that agree with it and people that don't, and let's see whether it makes its way through. And then we've got the Bullying and Respect at Work Private Members Bill, and this proposes to introduce legislation to give, for the first time, a legal and statutory definition of bullying at work to enable people to bring claims to the tribunal of bullying. So we have harassment, we're used to that, that's in the Equality Act, but there's no mention of bullying at all. So I won't spend time on it now, but when we do our next one, we should hopefully know whether that's making its way through. It's certainly had its first and second, no, I think it's had its first reading in Parliament. That was in December, and the second reading is due in June. So we'll see what happens with this. Private members' bills are hit and miss sometimes. But, you know, a lot of people argue it's important and that we should have legislation to outlaw bullying at work. But there we go, we'll wait and see. Then we've got lots of workforce crimes on the statutory books, which we already know about. For example, you have to lodge something that's called an HR1 form if you're making groups of people redundant, so collective redundancies, 20 or more people, you have to file an HR1 form, and there are payments if you don't do that. And fraud is the most common criminal offence in the UK. In fact, I read it accounts to 41% of all crime. So it's not surprising, I guess, that the government's clamping down on dishonest practices at work by ramping up the criminal liability for organisations whose employees or agents commit fraud for the organisation's benefit. And this new offence that will come in, if this becomes our legislation in the future, is the failure to prevent fraud offence. So it's very similar to the existing offence we have of failing to prevent bribery. So it will operate in a very similar way to that bribery requirement. So again, I'll tell you more about this when it moves further along, but again, it might require more policy, more training, more education. And then also, and the last sort of potentially new bit of legislation on its way is that when an employee leaves, many contracts include restrictive covenants and restrictive clauses. And the government has announced, and did quite a while back now, announced its intention to limit the duration of non-compete post-termination restrictions in employment contracts to a maximum of 3 months. So obviously non-compete clauses are designed to protect and give businesses protection against an employee seeking to work with a rival competitor, but often they're for lengthy periods of time. So with some senior contracts, I've seen those be 12 months or even longer. So the government's intention was to cap these at 3 months. And at present, there's no real detail about when that cap will be introduced, how it will work, but we'll watch out for those developments as well. And the last thing I wanted to mention before we finish is just to touch on the Labour Party proposals. So the next general election has to be held by the 28th of January 2025. And Mr. Sunak has recently said that it's likely that it will be in the second half of this year. Whether or not Labour Party will storm through the polls as they suggest they will is, you know, we wait to see. But they have said that there will be, if they are successful, some new employment laws within the first 100 days. And we kind of go full circle back to the first question that I asked you today, which is, how long do you have to be employed before you pick up your unfair dismissal protection rights? And it's 2 years, but the government has said that they will remove the 2-year qualifying period of service for claims and possibly remove some of the caps on compensation. Now, there's a difference between saying what you'll do and doing what you say, but we'll wait and see. Other proposals include banning 0 hours contracts, obviously lots of changes to the trade union legislation, so doing away with a lot of those restrictions and bringing in something called the right to disconnect, which we do see in some other countries. So lots of changes being proposed that we may or may not see should that happen. But there we go. So that brings me to the end of our 3 hours, and just wanted to see if there's any final questions that I haven't answered, or any questions that you'd now like to ask. If not, I hope that there's been a few reminders and a few maybe takeaways of what's on its way. And that's all from me. Thank you very much indeed. And thank you for participating in all the polls and questions too. So have a lovely day and a great weekend. Thank you.